Hey everyone, thanks for joining us. I'm Greg Christiana. I'm chair of the relatively new Civic Engagement Group, task group of Envision Arlington. And tonight I'm going to hand it over to our town council, attorney Doug Heim, and our deputy town council, attorney Michael Cunningham, to talk about warrant articles and some of the background of what goes into that. And to give us kind of like some of the framework of like how that process works, and maybe some tips along the way for folks, for residents who are interested in potentially drafting warrant articles or just want to understand the process better. Yeah, without further ado, Doug or Michael, do you want to, do you have material that you want to present, and just take it away?
Sure. Thanks so much. Before I share the slideshow, I just want to thanks folks for the opportunity to have Mike Cunningham, who's the deputy town council, and has sort of slid into a role where we used to have an attorney just for workers' compensation in the legal department, but now Mike both handles that and general government matters. He was very, very helpful in developing the domestic partnership bylaw that was initially brought to this office by an interested resident, and then was further sort of outlined and detailed with the help of the Rainbow Commission, and eventually ended up in the select boards, before the select board, all before the warrant closed. So we'll actually talk a little bit about that, but Mike can also help me answer some questions and share some of his perspectives on developing a bylaw that really originated from a resident idea, if not necessarily specifically a resident petition. Folks, for those folks who don't know me, I'm Doug Heim. I'm the town council. Forgive my lack of a suit this evening. I just got my booster shot a few hours ago, and so I made sure that I had some sleeves that are readily accessible. But as I was explaining to our wonderful folks who invited me, at least I'm wearing some Arlington burgundy. And with that, I'm gonna start sharing a slideshow that is going to be fairly comprehensive and address sorry, hold on a second. It's going to maybe go into a little more depth about some of the fundamental structure of state law and municipal authority that folks might expect, but it's my hope that this will help folks understand why the warrant article process oftentimes shakes out the way it does. And then we're going to get a little bit later on in the presentation into some of the sort of nitty-gritty details, and leave plenty of time to sort of field questions and provide some practical tips that I think are useful for people making the best and most efficient use of their time when they're trying to pursue warrant articles before town meeting. So at the start, it's important to understand the sort of Massachusetts background for how we arrive at being required to take actions through town meeting and what town meeting can do. So the town meeting form of government is obviously quite old, but around the early 1900s, cities and towns in Massachusetts were determined essentially by the court system to be political subdivisions of the Commonwealth. That may have been an idea that was in folks' heads politically before that time. But under the Dillon rule, the legal consequences of that came to sort of the forefront, again, in that early to mid 1900s period. And what it meant was that towns, and specifically, as well as cities, could only exercise limited self-governance as allowed by the state. And the result that we got from this period of time, which was roughly 1907 to the mid 1960s, is the state legislature basically was receiving a deluge of highly localized state legislative acts. So there were state legislative acts basically allowing a town like Arlington to buy or sell a piece of land. There were state legislative acts authorizing the town of Peabody to buy uniforms for its police department, or DPW. And it was a highly inefficient way of regulating things locally and conducting business. This all changed with the Home Rule Procedures Act and what we all call the Home Rule Amendment, Article 89, which reinvested municipalities with the authority in three chief forms. One was sort of reestablishing this idea of a general legislative power, that the town could essentially pass ordinances to regulate things that were affecting people's lives here locally. The second was it allowed for special legislation by home rule petition, and it tweaked the rules for how that works. I'm not going to get into too much detail on that, although there's a lot of interesting ground to cover there. And third, it provided for something called a home rule charter, which we don't have in Arlington. So again, the home rule charter is essentially a form of allowing a local constitution. For us, we call it the Town Manager Act. And interestingly, in Arlington, the Town Manager Act actually predates the development of this charter authority, because the town was sort of forward thinking, which may have been one of the models for developing this ability to essentially adopt a charter that said, you know, these are the authorities that the select board will have outside of what the general laws generally confer on a select board. This is how we're going to organize something like the Arlington Redevelopment Board. This is what right the Finance Committee has to certain information and how they'll be appointed. Basically giving us more flexibility, all towns, more flexibility than the general laws provide in terms of developing your form of government. And then of course, again, it also allowed for local legislative authority. In towns, we call them bylaws, both zoning bylaws and sort of regular bylaws. And then it sort of, again, further clarified how cities and towns might get additional authority to do certain types of things through special legislation that has to be approved by the legislature and the government. So this came along with not without conditions and restrictions. So specifically, the Home Rule Amendment said that governmental power of any city or town may, by adoption, amendment, or repeal of local ordinances or bylaws, exercise any power or function which the general court has power to confer upon it, which is not inconsistent with, one, the Constitution or laws enacted by the general court, basically meaning the authorities that the state has reserved for itself, or two, which is not denied either expressly or by clear implication by the city or town by its charter. So in our parlance, that would mean the Town Manager Act. You can't pass a bylaw that contradicts the Town Manager Act. You can't pass a bylaw that's inconsistent with state law. If you want to do either one of those things, you essentially have to go the route of special legislation and not only get approval of town meeting, but get approval of the state legislature and the governor ultimately themselves. The Home Rule Amendment also set forth a specific set of things that a town may not do by local ordinance. A town may not, by bylaw, regulate elections, levy or assess taxes, borrow money, dispose of parkland. This is a very broad one. Enact private or civil laws governing civil relationships, except as an incident to the exercise of independent municipal power. Provide for certain types of punishment. And again, that's sort of married with this idea of it can't be inconsistent with state law. So whenever I'm looking at a bylaw or a warrant article, one of the first things I'm doing is saying, is this preempted by state law? Is it in one of those 6 categories that the town is not allowed to govern? So a few Arlington basics. I alluded to this previously, because one of the things that happens a lot when we're in warrant article season is someone will say, well, they're doing this in this town, or even more complicated, they're doing this in Boston, Somerville, Cambridge. But those have different forms of government. Not every town is run under the same form of government. In Brookline, they have a town administrator, and their select board has a lot more day-to-day operational authority than our select board does. In Cambridge or Somerville or Boston, something I'll get into a little bit later, they don't have anybody essentially checking to see if their ordinances are consistent with state law like we do as a town form of government. Any bylaw that we pass, as I'll touch upon later, is reviewed by the Attorney General's office to make sure that it's consistent with state law and it doesn't get into one of those 6 areas that I mentioned that are forbidden with respect to town ordinances. So we have a Town Manager Act. As I said before, it predates the Home Rule Amendment, but it basically acts as our local sort of constitution. And then in addition to that, we have 465 legislative acts affecting the town. That's 465 pieces of legislation that were submitted to the state legislature at one point in time in our history, and were approved and are basically on the books. And some of those things are very, very specific to the time period that I mentioned, and other things are essentially what we call local options that give the town certain authorities or abilities to do something like enact a hotel excise tax. We have a select board and a representative town meeting with several more elected officials. Many towns have an open town meeting, which functions very differently. And then we have what is conventionally called a strong manager. So our manager has, by virtue of what's contained in the Town Manager Act, more autonomy in decision-making. He's the entity, or she would be the entity that's vested with the power to contract on behalf of the town, for example. So what is the warrant itself? The warrant is literally a warning. It's a warning of matters to be discussed at town meeting. And its basics are very simple. It has to say the time and the place of the town meeting and the subjects to be acted upon. One important thing for anybody developing a warrant article to understand is that a warrant article is not verbatim language of a vote or a motion at town meeting. A warrant article is usually a concise statement of what it is you want a town meeting to consider for action. So to see if the town will vote to regulate a specific thing, keeping ducks in the house, is the subject of the article. It does not have to say what all the penalties are, who will enforce that. That's not necessarily something that has to be set forth in the warrant, although for reasons we'll talk about later, it might be. Warrant articles have to be a sufficient description of what's proposed, again, so as to adequately warn the inhabitants of the town. And then also to make it clear what the scope of the article is. So if I've got an article that's an appropriation for telephones, and then I want to use that, and then I later want to change my motion or the vote or the action that's before town meeting, I'm actually going to vote upon it, to include telephones and bucket trucks to serve telephone lines. That's outside of the scope because my article didn't reasonably warn somebody that I was going to be talking about a capital item like a bucket truck. It only talked about telephones. In terms of the types of warrant articles, I just want to take a moment to sort of illustrate the most common things that are going to go into a warrant. Every once in a while, there's something that doesn't fit into these categories, but 99% of the warrant is going to fit into one of these sort of broad categories. So we have town bylaw amendments and new town bylaws. Those are essentially the legislative power that we've talked about, regulating different subjects. We've got working clockwise local options, resolutions, home rule petition or special legislation, budget appropriations, and zoning bylaw amendments. Getting into a little bit more detail, town bylaws and bylaw amendments are basically something that could be a detail of a local governance. Our town bylaws set forth when our warrant's going to be open, when we hold our annual town election, what committees and commissions are locally established and what their duties and powers are. They might establish a public health and safety ordinance. Recently, we've regulated plastic bags or single-use plastic bags. We do actually have a prohibition on feeding waterfowl in our town bylaws. There's some very, very specific and detailed things, and then there's some things that are very big ideas. And there are sometimes it's important to note that there's often some kind of local variation on state-given authority. So a conservation commission acts pursuant to state law, but we also have a local wetlands bylaw that we're essentially allowed to have on top of that, which further outlines specific issues and details that we might have a more specific concern about in Arlington. The same thing is true for a historic district commission or for community preservation act committee. Zoning bylaws and zoning bylaw amendments are a little bit more specific in terms of what they're about. These are basically land use regulations for purposes permitted under Chapter 48 of the Zoning Act and its predecessors. These have to be oriented towards land and its uses in the furtherance of health, safety, and general welfare of the town. And there are specific types of regulations that I won't get into too much that are prohibited, but those things include things that are subject to building code, the interior of buildings, and certain types of uses such as religious and educational uses, as well as agricultural. And then there are additional procedural elements and consequences of failure of a zoning article at town meeting. Next, we have local options, which again is an option that the state is basically already passed some legislation saying, hey, town of Arlington, if you want to do this, all you have to do is get town meeting's approval. So the best examples of this, or the clearest examples of this, are usually things like special taxes. We have a tax on marijuana sales or on a hotel room that basically we collect some local tax revenue for those uses. We have certain types of exemptions, tax abatements and exemptions for identified qualifying persons. The town doesn't have to have certain exemptions or abatements for veterans or the disabled or elderly, but we're allowed by the state to vote to decide whether we want those things. And then there's some special funding and spending mechanisms, as well as the delegation of other legislative powers from the Commonwealth. There are some things that are optional. You don't have to have a historic district commission, but if you do, you have to, in addition to adopting a bylaw about it, use their local option. Next, you have finance articles. These can be pretty broad ranging, but they're basically budgets, which are operating budgets, capital budgets, community preservation, certain types of borrowing, all types of borrowing have to be approved by town meeting. And then you'll see in any warrant a lot of specific appropriations, $25,000 for the removal of water chestnuts, or $10,000 for the Uncle Sam committee and events and celebrations. And then finally, you have basically two sets of things that are basically outside of the normal powers of town government. So you have a home rule petition, which seeks authority that's preempted or otherwise restricted under the home rule amendment. And these can be quirky things. If we want to hire a firefighter who's over 40 years old, the civil service law doesn't allow us to do that. We have to petition the legislature to allow a firefighter to sit for the firefighter exam if they're over 40 years old. Recently, we've had some other really big ideas, however, be submitted to the legislature as special legislation, which includes local regulation of fossil fuels, income-based tax relief, and ranked choice voting. As you'll recall from that slide earlier on, these are all things, some of them are specifically prohibited. So for example, we're not allowed to govern elections. So we have to get permission from the legislature through this special legislation to pass something that essentially allows us to locally regulate elections outside of the framework of what the state law strictly outlines. And then finally, we have resolutions. So these are usually things that are also outside the authority of town meeting and perhaps outside the authority of the Commonwealth. We've had resolutions in recent years on a number of things that are non-binding typically, but they're a statement of a value or an advisory position for something that town meeting doesn't necessarily have the ability to pass some sort of regulation with respect to. Some of these things are so we had a declaration of a climate emergency, for example, recently. We had a resolution about Prince Hall Day. These aren't things that are necessarily necessary for town meeting, but resident petitioners decided that town meeting was an appropriate and useful forum to debate and discuss them. I will say that it's also important to note that these are usually feature limited debate at town meeting per the rules of town meeting and the moderator's program. So a quick word on how things get on the warrant. The select board controls the warrant under the general laws. And so most warrant articles are inserted either directly by the select board or they're inserted at the request of some other town official or body. So the FinCom inserts, well, technically speaking, the select board inserts FinCom articles at the request of FinCom or the superintendent. or the manager or the tree committee. The other vehicle that many of you may be here tonight to sort of learn about is by registered voter petition. And there's a form, I'm sorry I don't have a copy of it, but there's essentially a form that you fill out that says, here's my warrant article, and I've got 10 signatures for annual meeting of registered voters who support me putting this on the warrant. And even if that warrant article is something that's not in proper form, it's not something within the scope of town meeting's powers, it will get put on the warrant as long as it was done by a proper 10 registered voter petition. Just to note, it's 100 registered voter for special town meetings. And as a general just sort of tip, I always advise getting extra signatures, because every once in a while, someone who signs your petition isn't actually a registered voter in town. They may be well-meaning, they may support your idea, but they might not be registered to vote. So the general template for these things is to see if the town will vote, and then it's to do something. So to see if the town will vote to establish a committee, outline its duties and powers, and set forth its composition. That's a very generally worded article. We have very specific warrant articles sometimes that say to see if the town will amend Title V, Article 10, yard sales, to relax yard sale regulations. Sometimes we have very, very, very general articles that say nothing more than require registration of saxophones and violins in the town of Arlington, and regardless of whether or not that's actually a legal article, if it's put on the petition and it's signed by 10 registered voters, it'll go into the warrant. And the sort of magic language, as Mr. Leone oftentimes says, is most of these articles should be capped with "or take any action related thereto," because it affords a little flexibility that this article about yard sales and regulations might need a fine or a fee associated with it, and that "or take any action related thereto" might give a little bit of extra wiggle room to make it clear that, yes, while I'm talking about relaxing those regulations, part and parcel with that might be, adjusting fees or fines for registering my yard sale. In terms of timeline, a lot of work can be done in a pre-warrant phase, but I'm just going to walk generally through the timeline of how the warrant gets developed. So usually in September to November, folks start approaching town officials or boards or my office about different ideas. Too much earlier than September, and it gets pretty difficult to keep something on the stove, or at least it gets put on the back burner because there's lots of other business to attend to. And then the warrant opens the first week of December, and it stays open through the last Friday of January. So folks do have a lot of time to develop a warrant article, but it's only available to be put on the warrant during that period. Then there are warrant article hearings. They have slightly different schedules depending on who is the sort of host of the warrant article hearings. If it's a zoning matter, it goes before the ARB. If it's a general legislative matter, it goes before the select board. If it's a financial matter, most of those are going to go before the FinCom. Applicants for CPA grants are going to go in front of the CPA first. And those generally take place February through March, although sometimes finance committee hearings can stretch into April while town meeting is actually happening. It's during this period of time that the warrant article might transform into a motion or a vote. So again, your article is just a notice really about what you want to talk about. And that doesn't necessarily mean that you have to have the exact thing that town meeting is going to vote on. I want to strike these 3 words in section 8.3 of the zoning bylaw and replace them with these 4 words. Or I want to establish a new committee or commission, Title II, Article 16, and this is exactly what the composition of the membership is going to look like and how they're appointed. That usually happens alongside the warrant article hearings. I'll talk a little bit more about this. Some of these bodies expect you to be a little bit more prepared than others with the draft motion at their hearing. The ARB, it's more typical, for example, for them to want to know exactly what you're proposing. The select board might be a little bit more flexible if there's an idea that they're supportive of. They might even direct this office to either draft the motion or to help draft the motion or work with the proponent. And then town meeting is April through whenever we wrap it up. Approved town and zoning bylaws get reviewed by the Attorney General's Office, Municipal Law Unit, basically July through September. Approved home rule and special legislation is generally submitted to the legislative delegation in July and August. There are occasionally reasons why it might take a little longer than that. Approved budgets and appropriations are generally go into effect 7 days after the dissolution of town meeting, and local options and resolutions are essentially by effective date or immediately. So how an idea becomes a warrant article. So getting back to this pre-warrant development, you've got a problem and you want to look for a potential solution. The first thing that I recommend for folks is to look at whether the issue seems to be within the town's jurisdiction. And if it's not within the town's jurisdiction, that doesn't necessarily mean that you don't end up with a warrant article, but you'll know pretty early on whether or not you're talking about special legislation or something that's more along the lines of a resolution. And that'll help you sort of figure out where you want to go before you start talking and shopping your idea around. And it's very much appreciated by professional staff, committees, and commissions when they have a good idea of whether or not they're really going to be talking about a bylaw or something different than that early on. There also might be mechanisms in place to address the problem, or doesn't necessarily have to be a problem, the idea, without going to town meeting. It might be something that could be addressed by a town policy under the manager or the select board. It might be something that might be addressed in rules and regulations or practice by a committee or commission. It might be something that's best framed in lobbying for state action. And then, the sort of next step there is to formulate your draft article. It doesn't have to be perfect, but it's helpful to just have some sort of idea sketched out on paper. Once you've sort of got that idea sketched out on paper, it's important, I think, to contact my office, potentially the planning director, department heads, boards and commissions, because I think that while sometimes town meeting can involve disagreements, there's oftentimes more room for agreement than folks think. And you might end up getting the support of a town department or department head or a board or commission going into town meeting, going into the warrant article hearings. And they might have comments on what they'd like to see a warrant article look like, what features they might like to have, what things they don't want to see, what problems they're experiencing or potential issues that they see. It's also important to identify potential areas of disagreement. A lot of times I feel like, I'm not sure about this, there might be some folks who are reticent to put their warrant article in front of me because they're worried that I'm going to say, well, I don't think the town can do this. But the reality is it's better to know that than to not know that. I'm not going to tell somebody that you're not allowed to submit a warrant article. I might say, I don't think this is within the town's authority, or the only way I can see you doing this is through a special act. But it's better to know that than to have me stand up at town meeting or at a select board hearing or someone at a redevelopment board hearing or a finance committee hearing say, I don't think that this, as it's been presented, is legally feasible. It also is helpful to start thinking about what the scope of the article should be. I want to take some time for questions in a few minutes, but also drill down on this in our last slide a little bit more. I think strategically, folks have to think about the process and how open they are to sort of consensus building over time, or how much they're very much wedded to a very specific vision. And there's nothing wrong with that, but it might inform the way that you develop your article. I think I covered those other points. So once you finalize your vehicle and your language, so I'm submitting a warrant article. It's a warrant article that's proposing a bylaw amendment, or it's proposing a resolution. Again, you want to be mindful of scope and form and action. If you submit a warrant article that says, I want to amend the town bylaws to do something, and then you change your mind later on and decide, well, I think this is probably more appropriate under a special act. You're kind of stuck. It's unlikely that the moderator is going to allow you to submit something to town meeting in the form of a home rule petition or a special act if you've committed yourself to pursuing a town bylaw. And similarly, like I said, our most specific town bylaw amendments, I'm sorry, not town bylaw amendments, our most specific motions, warrant articles, tend to be zoning articles. And there's some reasons why that I can unpack if people would find it interesting. But oftentimes when you see a warrant article about zoning, you'll see the warrant article itself contains what looks like a motion. It says, I want to strike these things. I want to add this. I want to redefine this term as this. And then it might say, or take any action related there too, but it's a fairly specific and narrow scope. And that can be for a couple of reasons, but one of the reasons it's often the case is because people don't want to have something that's drastically different by amendment or some other process than what they're proposing. They see it more as an up or down idea, and that's okay. But you can craft a warrant article to give yourself more and less flexibility, and there's nothing really wrong with more open-ended warrant articles, as long as, again, it's not unreasonable to think that somebody would know that this could come out of it. So if we're having a warrant article to discuss, the Affordable Housing Trust, it wouldn't be reasonable to expect that there was going to be some kind of alteration to the local wetlands bylaw that's a part of that motion under that warrant article. I think it's also important to really be considerate of the meeting. So Arlington has infamously long and spirited town meetings. There are some things that come back to the meeting that have already been recently discussed and decided. There are some things that might be discussed in other forums just as effectively as they might be in town meeting. It's not ultimately for someone like me to decide what's a good use of town meeting's time, but it is helpful to think about if you've got an idea that isn't ready for prime time, as they say, or you you might have redundant warrant articles that are very, very similar to each other, or you're submitting 5 or 6 warrant articles about similar subjects. That's going to eat a good chunk of town meeting's time. Town meeting wants to afford time for people to really sit down and think about and debate the substance of warrant articles. But as the meeting winds on, especially in the virtual format, the town meeting does need to wrap up by mid-June. And it starts to feel a little bit rushed, at least in some folks' mind. They reported to me that sometimes they feel a little bit rushed because of the volume of articles on the warrant. I don't remember how many we had last year, but we had as many as I can remember. Back in, 2017, our annual town meeting warrant had 60 articles. I want to say last year we had something in the high 80s or low 90s. Not including special town articles. I also think it's important to confer and work with potential friends to your article, and that might be other individuals. I think that there are a lot of folks who have sort of learned how to make connections with folks who are either similar minded or might have differing views on an issue, and they sort of work out some compromises and I don't want to say alliances, but make things a little bit more comprehensive before they even submit a warrant article, because they've really talked about it with neighbors and stakeholders in their community. And within that vein, I think it can also be helpful to consider and plan for sponsorship. So as I was referencing earlier, when I believe it was Guillermo Hamlin first approached us last year about the legal department, about the legal aspects of a domestic partnership bylaw. He set aside some time and I think wanted to make sure that this was something that was amenable to the Rainbow Commission. And the article sort of developed over time so that the Rainbow Commission had some time to basically vote in support of putting this article on the warrant. And then Mike, you can correct me if I'm wrong here, but I think if my memory serves correctly, there was also time for the select board to vote to also support putting it on the warrant. That type of thing just sort of builds momentum and spots issues early on, which can be really helpful. Um, and while we're really here to talk about warrant articles and not necessarily about the rest of the process, I'm happy to talk about that. My last sort of word on this before we sort of open it up a little bit more is that one should remember that your article is not your motion and your motion may not be yours. So one of the things that happens quite frequently is that somebody has a terrific idea. They put it down in the form of a warrant article, and that warrant article gets in front of the select board. And the select board says, boy, this idea is great. We'd like to do A, B, and C with it. That may not be what you ultimately saw for your warrant article, but the select board or the finance committee or the redevelopment board, they have the standing to basically have the first motion before town meeting. So it's possible and happens quite frequently that these boards and bodies like the ideas that are brought to them and they want to build upon them. And sometimes they want to change them. And you have to sort of think about both in developing your article and then in sort of seeing that article through the process, how much you want to have that idea influenced or altered or changed in a sort of consensus building process. Because sometimes the select board, for example, will tell me, Doug, we want you to draft a motion on this warrant article that says, X and Y. And the article proponent will say to me, but wait, that my article, I wanted it to say, A and B, but now it's saying X and Y. And it can be difficult for me because I think sometimes folks think of me as, someone who is working with them. And it's not that I'm not working with you in the warrant article stage, but the select board is ultimately, or the finance committee or the ARB, or ultimately the clients of the legal department. And if they want to take the warrant article in a different direction, as long as it's in the scope, they're allowed to do that. That doesn't mean that your options are foreclosed. You might join them. You might argue and lobby and push to have a vision that's a little bit closer before those bodies. You might also submit a substitute motion at town meeting that might have more fealty to your original vision for something. But it's just important to note that right now, at this phase, all you're trying to do is develop a notice to the town, the community, of something that you'd like to discuss, and make sure that if it's that it's within the town's power and jurisdiction to address it, and if it's not, to figure out where you want to go from there. And folks like myself, a lot of other professional staff, are happy to work with people as best we can. There are times, but I'll admit that, especially during warrant article season, I get a little bit overtaxed. I have the rest of my function as a town council to perform, but then also researching sometimes ideas and issues that I've never looked at before. Greg is well aware that I didn't know anything about ranked choice voting when ranked choice voting first came up, and I still needed to work in concert with a lot of the folks on the election modernization committee to make sure that I was understanding things correctly and being as helpful as I could. But if folks submit a warrant article 2 days before the deadline and say, Doug, what do you think? This warrant article is to fundamentally transform the way we do some aspect of business in Arlington. It's going to be hard for me to give you a thorough analysis to work with you. I am happy to work with folks. I'd like to think that my office has helped a number of folks put their article in the best position, even if it's not necessarily something that the manager or the select board or the conservation commission or the redevelopment board is necessarily something that they are inclined to support. We see that as our duty to try to make sure that things are in the best shape as possible. What I never want to see happen is someone be surprised later on down the road, or to be told that something's not in proper form or won't be in scope. So we want to make sure that the debates in Arlington are as robust as they can be, and that folks have a genuine opportunity to present their ideas before all these bodies that vet warrant articles before they get to town. So I've talked for a long time, so I don't want to go any further, but if folks have questions or they want to just sort of chat about more specific elements of strategy, talk about specific ideas that they have, I'm here for any of those types of questions as well. Thank you.
All right, thanks, Doug. Thanks so much. That was I found that really helpful in clarifying about the overall process. So any questions from the audience? Beth, go ahead.
Thank you, Beth Malofchek. Doug, can you explain what exactly the function and what it means, this phrase, or take any action related thereto, that's tagged on the end of the draft warrant articles, please?
Sure. Nice to see you, Beth. That's a really good question. That's suggested language. It's not necessary, but it's suggested language in basically every warrant article because it essentially is a wiggle room provision. So again, if I want to have a warrant article about establishing a committee or a commission to examine a certain issue, but I haven't outlined every single thing that the committee or commission might address in some sort of list in the warrant article. And someone later on says, well, is it within the scope for this committee or commission to consider, geese instead of ducks? As long as it can reasonably be tethered to the purpose of the article and what it's meant to address, that or take any action related thereto will cover you in a future motion or amendment or something like that. There are some limits to that. Generally speaking, for example, for finance articles, you can appropriate less than you put in a warrant article, but not more. The finance committee is also loath to see somebody submit something under a town bylaw that then they ask for as a part of a vote an appropriation. That's something that the finance committee hasn't had an opportunity to work into a budget or really consider. So money usually is something that's going to be outside the scope, even with that, or take any action related thereto, because there's a specific reason why you would want to have a more notice on it. But the idea is really that it helps usually the proponent. It helps the proponent not be bound too tightly to the four corners of whatever the language of their warrant article is. And that comes up sometimes in like zoning, for example, if there's a zoning provision that's trying to regulate foundation size, but it didn't incorporate or think about porches or something like that in the original formation of the warrant article. If the warrant article is phrased broadly enough and that or take any action related thereto can be reasonably construed to say, hey, it's pretty clear that they meant to include porches in this, or we think that's within scope. It's going to help folks before the moderator not get ruled out of scope on some motion or amendment. So that's generally the idea. It's usually helpful. I will say that every once in a while, just in full disclosure, folks can find it frustrating because they didn't want some action contemplated under their warrant article. They didn't want something to be referred to as study committee. That's one that or take any action related to has a very broad application to. So let's say I had a warrant article that wanted to propose altering the criteria for what should be considered under the Historic Commission's purview. We had a few articles about that recently. Or take any action related thereto might give the room to refer that matter to a study committee. But without that language, someone might say, well, there's no contemplation of referring this issue for further study. It's an up or down matter. Does that answer your question?
It does, and I have a follow-up. So I had this phrase on one of my draft warrant articles, actually a draft resolution last year, and one of the members of the select board, it gave them pause, is how I'd put it. And they had a great concern as to what that meant. This was the the one on the tree canopy as a public health
Yeah.
resource.
I recall.
So, and I didn't know what I put it on there because I saw it on all the other Warrant articles. So I really couldn't explain. I mean, I hadn't anticipated this particular select board member's horror and concern, because I thought it was just a, sort of pro forma legal thing that you put on.
Yeah, I mean, it is oftentimes pro forma, and I would almost always recommend it. I mean, it's a very specific choice not to do that. I think if I recall correctly, in that circumstance, I think the concern of that member, whether one thinks that concern was good or bad, was, if you have a warrant article that's about a resolution, and that resolution includes or take any action related thereto, maybe their concern was that they thought it might turn into some sort of bylaw or regulation. I don't know exactly what was in their head, but in most circumstances, it's a good thing, not a bad thing to have that there. There are going to be some times when folks have concerns about something that could be construed very, very broadly. So when you have a broad warrant article, and I'm not saying yours was, I don't recall the language of it specifically, but if you have a very broad warrant article, to see if the town will increase loosen the criteria for what is considered historic, right? Or take any action related thereto. There are going to be some folks that are worried, and they say, well, wait a second, what is this meant to encompass? Are we talking about, a revision to the bylaw? You will see folks every once in a while put in a warrant article that just says vote. They don't specify whether it's a bylaw or a resolution or something like that. That isn't necessarily a bad thing. Sometimes folks want to wait, or they don't have time to perfectly flesh out where they want to go with something. But I think it's more often than not going to be your ally rather than your hindrance. So I remember that situation, but I would continue to put those in any warrant articles that I'm submitting.
So this was a resolution. As I understand it, resolutions are non-binding. So this phrase should have not presumably had anything to fear in it.
Yeah, I mean, I don't want to get too caught up in a specific scenario, but I think that there's a difference between a warrant article and a motion. And I don't recall the context if we're talking about a warrant article or a motion. For a warrant article, if you say or take any action related thereto in a resolution, I'm not sure what the moderator would say. He probably would say, well, you submitted this as a resolution. But if you tried to make a resolution into a bylaw amendment of some kind, when you had that language, you'd at least have a chance. Maybe that's what they were nervous about.
Okay, so it's something that could have happened on the floor. Okay, thank you.
Yeah.
I took up enough time.
Well, not seeing any other questions. I do have a question of my own, just on a technical question on terminology, right? So I feel like I should know this by now, but so there's the warrant articles that actually get printed and kind of distributed to everyone in town as the announcement, right? Like the warning, right? Like you said. And then there's what we vote on, town meeting members vote on at town meeting. And those are also called articles. We're voting on Article 7, right? And is that also a warrant article, just at a later stage of evolution, or is it a different thing?
So what the articles become, that's a great question, Greg. What the articles become is essentially agenda items. So that's one way to think about it. So where Article 35 is laid on the table and before town meeting, that's what we're discussing. But if you look at the select board report or the FinCom report or the ARB report, you'll see that there's a motion under that article. The article is the sort of agenda item that we're talking about. So that's why the phrase doesn't really go away. But that article is going to read exactly how you've submitted it by 10 registered voter or as the select board put it in. That article is never going to change. Once it's in, it's in. There's a academic debate about whether resident petition articles can be changed on consent of all the signatories before the warrant's published, but that's not really a useful use of our time right now. But the article will never change, but the motion before the meeting is what you're actually going to vote on under that article.
I see. So we call it the article, but like on the floor of town meeting, like it's in the context of an agenda item that has a motion associated with it, and that's
right. That's right. So the article is the agenda item. So that's just how we sort of organize our actions, and you can only take an action at town meeting underneath something that has been posted in the warrant. You, in theory, can do almost nothing at town meeting. There are some charming sort of things that we do in Arlington that are traditions. There are some resolutions that aren't, they're like floor resolutions. There's the appointment, even the appointment of the measure of wooden bark is an article on the warrant. So any action, any vote by town meeting other than a procedural matter has to be pursuant to a duly noticed article. And it's the vote or the motion, usually it's phrased as voted, that you're actually taking an action. And by the way, it gets more confusing because Arlington is particularly precise on zoning matters. So it's more common here than it is in some other communities. There is a reason, but that the zoning articles, the article looks almost identical to the motion, which makes it look a little strange. And especially when those matters are dealt with first, it can make it seem like the article is what you're voting on. The article is what you're taking action under.
Got it.
If folks don't have questions, I think I'd be happy to answer as many questions as folks have, but I'd also give my deputy town council, Mike Cunningham, just an opportunity to walk through how he worked through the process, working through his first couple of warrant articles last year that we sort of, this office helped develop or helped vet. Mike, did you want to add any comments in terms of just your general approach when folks contact the legal office? Usually folks will email me and then I'll try to assign them to either myself or Mike. I've got quite a few, I'll be honest, on a backlog right now that I haven't responded to yet, but I promise I'll get there. So Mike, do you want to share a few thoughts about how you approach these things?
Yeah, thanks, Doug. And thanks to everyone here and thanks to our hosts. But yeah, last year was my first time in the town of Arlington working through the town meeting process. I've been a part of town meetings in other communities, but I'm happy to serve as a resource for anybody who's looking to work on an idea or a concept. That's a big part of what I'm trying to do here and be helpful. Last year we worked on a few, and in particular, Doug already mentioned the domestic partnership bylaw, and that was something I worked with a resident on and a group of residents in the end. And the process was as Doug laid out, where we come up, the resident comes up with an idea, a warrant article, and then we worked from there to come up. In that situation, it was actually not the amendment of an existing bylaw, but rather the creation of a new bylaw. And so we worked in drafting a proposed bylaw, which essentially served as the motion, and that was kind of relates to Greg's question. There was a proposed bylaw that was submitted for the vote, and then we worked through the select board process. And I just, through the entire process, both the initial drafting, working through the select board, motion hearing, and then also town meeting, serving as a resource for residents to work with them on their concepts and ideas. Not necessarily as an advocate, like Doug said, I'm not a proponent of one way or the other. I just want to make sure that things that, to the extent that we can, are in the best form, and that people are able to appropriately and legally express their ideas and put them before town meeting for debate and discussion. And I'm happy to serve as a resource for anyone in town who would like help with a concept or idea. And I am here at the office with Doug, and please reach out to me anytime. I'm available and ready to help. So thanks for having me too.
I have to say that one of the best things about warrant article season is that the reality for the legal department is that for most of the year, the legal department serves essentially the town boards, bodies, and officials. We're forbidden from advocating on behalf of or providing legal advice to residents directly. That's something that's a big no-no. in the world of municipal law. But this is sort of a special exception. It gives us an opportunity to work a little bit more directly with both town meeting members and just residents who have ideas. And again, sometimes our role is pretty limited to saying, this is what we think you can do and this is what we think you can't do. Where we can provide some helpful suggestions with respect to language, we try to do that. I just want to emphasize that it's always going to be yours, unless it becomes the select board's is submitting a warrant article or a committee or commission submitting a warrant article. I don't want to ever give the impression it's your article. You don't have to take our sort of advice. You can do it on your own, but we try to be as candid and helpful with folks as we can, because it's in everybody's interest in our mind to have well-formed articles and well-prepared discussions.
All right, any other questions?
Yeah, I'll ask a question.
Go ahead, Alex.
The recent state housing choice legislation that kind of shifted the threshold for some zoning bylaws from 66 to 50. Can you talk a bit about the process for figuring out which a given article would fall under and how it might or might not shift as it goes through evolution of the actual motion, and who makes the decision about which it falls under?
Let me work backwards from that. That's a great question too. Generally speaking, the moderator and I will decide on what the quantum of votes that's necessary for a given vote at town meeting. It's in everyone's incentive to get that right, because again, all these things, every vote of a zoning bylaw amendment and a town bylaw amendment has to be sent to the Attorney General's office. The Attorney General's office has to receive a certified copy of the vote, including the quantum. And if they disagree with, if they don't think a bylaw was subject to the reduced majority, the reduced requirement for a simple majority, then that bylaw hasn't really passed. And so it's not really helpful to anybody. I suppose if it's a matter of your strategic thinking, I will try to offer an early opinion as to whether I think it's subject to 2/3 or simple majority. But I wouldn't necessarily have that dominate the construction of your warrant article. If you want to sort of talk about that when you submit something, it's definitely something we can do an analysis on to try to give you an idea. But again, you might find the dimensions of that changing, and it might depend a little bit on the ARB's reception. The ARB might make a suggestion that says, hey, if you did these couple things, we think that this might fall under a reduced requirement in terms of simple majority. Or they might say, we're not supportive of this idea, and we think that the quantum of votes that you need isn't realistic, given town meeting's previous position on this. So it's a little hard for me to answer on my own. I would be happy to give you a sort of forecast if you submitted a warrant article on one of those subjects, and it can be very, very fact specific about whether or not it qualifies for that simple majority or not. So I can give you a forecast, but as you said, it might change depending on the language that comes out in the motion, and ultimately the moderator and I would have to decide whether we think it's subject to simple majority or 2/3.
Great, thank you.
Doug, can you talk about the distinction of recommended vote and no action once a warrant article is gone, a draft warrant article is gone, for instance, before the select board?
Yeah, I'd be happy to. So when you draft any warrant article, and you have your hearing before the Finance Committee or the ARB or the Select Board, one possible outcome is that that body decides they're going to recommend a vote of no action. If they recommend a vote of no action, that is the default motion under the article before town meeting. That doesn't have to be the end of it. If you are a town meeting member, or if you get a town meeting member to submit a substitute motion, that substitute motion gets voted upon as to whether or not it will supplant that vote of no action. The substitute motion has to be within the scope of the warrant article. Sometimes the substitute motion is the original thing that was pitched to the Select Board or the ARB. Sometimes it's different. And as long as it's within the scope, you'll have the opportunity to present that substitute motion. You just need to make sure you have a town meeting member sign and submit that substitute motion.
So it doesn't have to differ. It could be the exact same thing.
It could be the exact same thing.
Wow, I didn't know that. Okay. And are you able to say anything about the impression that no action or recommended vote has kind of this weighty, almost sacrosanct ruling?
I appreciate you asking about. I mean, yeah, I don't. I've seen that go a bunch of different ways. I've seen. I would say that generally speaking, no action votes present town meeting with a relatively straightforward and simple choice, right? If somebody says, okay, we've got a recommended vote of no action, there's going to be some town meeting members who might be inclined to say, all right, well, I'm not that interested in a substitute motion. But I found it to be, again, I found it to be hard to say. It really depends on the subject matter, and it depends a little bit on the board and body. It's rare that you see, for example, a recommended vote of no action by the Finance Committee get overturned in a substitute motion, because the burden there is to identify what you're going to take out of the budget to, essentially fund something that they've voted no action. The Select Board and the Redevelopment Board, I don't know. I would say it's probably a tougher road to hoe, but I wouldn't say it's insurmountable. I've seen plenty of substitute motions overcome a recommended vote of no action from the Select Board or the ARB.
Okay, thank you. And will your slideshow be available online?
Sure, I can distribute it. Yeah.
Thank you.
Okay. Any other questions?
Yeah, great. If I could say one other thing, I really do think, it's been a tough couple of years for everybody, and there are times when, I really have to sit back and be grateful for the opportunity to serve as town council, because this is one of the most interesting jobs that you could have in the law. It didn't take us a lot to persuade Mike Cunningham to come from private practice, in part because this is a lot of the stuff that lawyers dream about. It is really, really fascinating stuff to think about and be educated about, and to participate in this very direct form of democracy. And we all in the legal department, and I do think at the end of the day, even where there's sometimes some conflict, all the folks who serve on boards and bodies and commissions, the professional staff, just feel like we're really in the middle of interesting, fascinating stuff, and a community that really cares a great deal about its present and future. So I'm grateful to all of you for joining me. I know that the subject matter can be a little bit dry sometimes. I even board a bunch of municipal lawyers in my recitation of the Home Rules Procedures Act not that long ago. So I really appreciate folks' commitment to learning about this kind of stuff. And I appreciate the civic engagement group kind of getting on top of this and providing some more opportunities. I think that we're open to hearing about what other resources might be useful. I know that some communities have more in the way of written materials about their town meeting processes and procedures. So, if folks have suggestions, I think that the Civic Engagement Group is just such a terrific way of having a discussion and distilling down different ideas for ourselves, the moderator, the town meeting procedures committee, lots of different folks. So thank you, guys.
Great, thanks so much, Doug, and Mike as well. So we do have another 20 minutes if folks have questions or any points of discussion they want to raise. If there are no questions, we can give folks 20 minutes of their evenings back. So last call for questions, or any further points you want to make, Doug, with this?
I would just say, if anybody wants to talk about a warrant article, an idea that they have, I wouldn't be embarrassed to do it. I mean, I've gone to a few of these types of meetings over the years in precincts in person, and folks just sort of pitched ideas about things that they were interested in. And if folks would like to walk through sort of what Mike and I would do for an analysis, if you have an idea, I find it strange. It's weird. For some reason, I cannot think off the top of my head of all the different things that have been raised over the years, including some things that didn't happen. Actually, I have one example that I could raise. But if anybody wants to talk through something that they're thinking about, I'd be happy to do it.
Len, you had your hand up?
Sure. So something I'm thinking about, it comes out of the Fair Housing Action Plan. And I know when my first year of town meeting, someone had brought it up. And I actually saw it go before the select board in a hearing, because I was covering things for ACMI. And that is changing the start time of town meeting. Now, I know that that's something that the moderator controls. So it really would be pointless for town meeting members or residents to kind of file in a petition to have that changed.
Well, I think I'd have to look at this a little more closely, but I think that the town meeting is set by the select board in terms of its date and time. So if we could talk about that a little bit more, but
I'm sorry to interrupt, Doug. I meant the start time of the sessions. So instead of starting at 8 o'clock, starting earlier in the evening, because that's what was meant. That was the issue in the report on the Fair Housing Action Plan. And I know it seems like it's a stretch from housing, but the whole point was that a lot of things that could be changed would be changed through town meeting, and it's hard for people to participate in town meeting when it starts late and ends late. And so that's what I was getting at.
So Len, I actually think that that's in the town bylaws. I have to double check on that, but I'm actually pretty sure that's in the town bylaws that it says we start at 8 o'clock. I think what you may be referring to is a really good example and a point of discussion. When we talk about something as sort of tradition and practice heavy as town meeting, there are really important stakeholders to confer with as early as you can. So the town meeting procedures committee and the moderator might have very, very strong feelings about what they want to see from town meeting. And they may also have memories from debates past. But that doesn't necessarily mean that you can't submit a warrant article about it, but it might be the type of thing that you might set up by saying, hey, can we have a vote at town meeting or a non-binding discussion at town meeting, a resolution to discuss changing town meeting start time as a sort of way of gauging the temperature of that issue. That's a relatively discrete item that might benefit from getting town meeting while you have them. So that might be one way to approach it. I think it's in the town bylaws. I could be wrong about that, Len, and I apologize if I am, embarrassed if I am, but I think it's that the moderator and the town meeting procedures committee has had some resistance to it based on their experience, and their recommendation to change it or their willingness to have a debate about it might go a long way to advancing it before the select board or whoever.
All right, thank you.
I'm mindful of you wearing different hats right now, so
Yeah, I believe James Fleming, I think you had your hand up next.
Yes. I was wondering if you were going to follow through on your. Oh, sorry, hang on. My camera. If you'd follow through on talking about a particular warrant article being eligible for housing choice.
Sure. What would you like to?
Sure. So the one I was thinking of is it's pretty simple. It's changing the minimum parking requirements for apartment buildings down from there's a tiered structure now, and it would be a lower number and a flat rate for everything. And I'm reading through the what I can make of the guidance from the state on whether it qualifies or not. It's not entirely clear because there's a language in there that says that it's eligible if it reduces parking requirements for residential development under a special permit, and it wasn't clear if that means that the parking reduction is tied to a particular special permit, or if it applies to a class of use that is allowed by special permit or some other reading. This is where I was looking for help.
Oh, so I missed that last part, James.
This is where I was looking for help.
Yeah. So the answer is I'm not sure off the top of my head. What I would want to do is what I'd have to do is think a little bit more about it. And I would be happy to give you. I know that you emailed me about this, so I'm sorry I've been a little bit back.
That's okay.
But I'll certainly get an answer for you on that. But just for the sake of the sort of general tenor, this is exactly the type of thing that I want to encourage folks to do if they've got questions in this nature. And they want to think about how they should structure their warrant article so that it might or might not be eligible for this. I can provide some perspective on it and try to get you in the best posture. I feel like in any borderline case, I would want to assume that you've got to get over the 2/3 and be happy if you don't. But I'll look at it a little bit more closely. It's something that I need a little bit more time to think about. And just so you know, one of the things that I can do, our Attorney General's Office Municipal Law Unit, they may be the guardians and gatekeepers, and sometimes they can be frustrating, but they're also very generous with their time, and they have a library of decisions, but they're also willing sometimes to talk it out with someone like me or someone or residents directly and say, what they think of something like how they might interpret it. So it's something that I'm happy to connect with you personally with a little bit more.
Okay, thank you.
Great. Let's see, Kristen, I believe you had your hand next.
Yeah, hi. I'm interested. I think I have a couple of really good ideas for warrant articles. And one of them is just a non-binding resolution, which would declare that the town of Arlington wants to have the combined sewer overflows in the Alewife Brook closed and wants a boatable Alewife Brook. And so I was wondering what Attorney Heim thought about that.
Sure. So, any resolution like that, what I would encourage folks to think about is what is the overall goal and purpose of getting town meetings voted? If you feel like it's imperative to spurring legislative action, if you feel like it is educational for the meeting, those are some reasons that folks might submit a resolution. The select board might in and of itself be a sufficient forum, right? So, the select board, the advantage of it is you can get on an agenda to talk about combined sewer overflow whenever you want. And I know that there are several select board members who are very concerned about those issues as well. The end issue that you're probably trying to get at is spurring agency and state legislative action that would be necessary to receive that end goal. So I guess what I encourage folks to think about when it comes to resolutions is, do you feel like you need town meeting to get where you need to go? Sometimes it's not about that. And I do recognize that there are some things that have come before us the declaration of climate emergency certainly seems like one that a lot of people are very responsive to. And I know we've had sanctuary town and some other things like that, that also were basically a statement of community values. The more specific an item is, sometimes the more I think it bears thinking about, if I can get where I need to go without town meeting, town meeting can be an awfully long process to go through to get something that you might get out of your chief elected executive officials. So that's my only comment. I mean, there's nothing that would prevent you from submitting a resolution about this. Usually resolutions are sort of that nature, of some sort of declaration of something that people want people to be concerned about or take a specific action towards. But again, because it's not something within town meeting's authority, the question for you to ponder is, who is going to be who am I gaining leverage with by getting this resolution at town meeting? If you feel like you're getting something more from the legislative delegation or from the agencies, then maybe it's something you want to consider. But if you don't, I wouldn't say that means, oh, don't do anything. It's more like, is the forum some combination of the Conservation Commission and the Select Board? Is that the right place to try to get folks to say something about this combined sewer overflow problem?
Well, I guess my feeling is that if town meeting were to pass this non-binding resolution, it would be a much stronger message to send to there are a couple of hearings coming up, some big decisions that are going to be made in the next 6 months. So maybe it's something I could even do, but I could go before the select board and ask for their support and then also bring it to town meeting. Does that sound extremely wasteful to you?
No, I mean, those things aren't mutually exclusive. I don't have the political wisdom that other folks have in terms of knowing, that's sort of outside my pay grade a little bit in terms of what's, politically smart or useful. But there's nothing that would prevent you from doing both. I don't know what the timeline for your hearing is, but just be aware that, a resolution of town meeting probably isn't getting voted on until June.
Right. Okay.
So that's, from a practical standpoint, something to think about.
Yeah. Okay. Thank you very much for your time. I appreciate your input.
And I know that so many of us share, as somebody who votes a lot in the Mystic, I know that a lot of folks share this serious concern.
Well, so much work has been done on this issue in the last 20 years, and so much more can be done. But it's not going to get done without a political solution where I think really strong messages get sent that we want the CSOs closed. So, yeah, so thanks for your time. Appreciate it.
Sure.
All right. Bye.
Okay, so we have 8 minutes left, and Rebecca, you're our last remaining hand up. So unless there are other questions, and if there's any time, Rebecca, why don't you go ahead?
So Doug, I understand you're entertaining brainstorming, correct?
Yeah, that's right.
Okay, so I recently became aware that a neighboring community, Inspectional Services, raises its funds by essentially charging a percentage of whatever the project is, whether it's a major renovation or new construction. And it occurred to me that that's not necessarily what our inspectional services are charging, and that this might be a way to generate some significant revenue in town, given the amount of tear downs and new construction. So is that change appropriate for a warrant article would be a question. If it is, could such a warrant article specify that any funds that are raised end up in the Arlington Housing Trust Fund, or is that too specific? And if it's a reasonable idea, would the next step be, for example, to go to Charlie Foskett and the Finance Committee to see what their sort of thoughts about that type of revenue generation for the town would be. And am I making any sense? Because
No, you're making a lot of
off
sense.
the top of my head.
And those are great questions that I think help illustrate some of the steps that folks can take. So the first set of folks that I would inquire with, we have a new building inspector, Mike Champa. I'll be honest with you, my understanding is that that's how building fees work in Arlington, that they charge a percentage of, based on, essentially what the work is that's being done. And there may be some room at the margins for, some communities might calculate a little differently than others, but I'm not an expert on that. I would confer with Mr. Champa, because that may well be something that, it's more of a matter of, again, margins than mountains. It's also an example of something that I'm not sure about this, but I think is probably set forth in the building code rather than in a town bylaw. So if it's something that's in the building code, that would be preempted by state law unless we pass some kind of special act. Germane to that, with respect to affordable housing trust, your idea about can we take a percentage of building permit fees and apply them to the housing trust, I think the answer is we probably could do that through a special act, but that's what we're dealing with. We're probably not dealing with a bylaw. And if everybody, starts thinking about that now, I know that the Affordable Housing Trust, that the folks are working on the declaration for that Affordable Housing Trust, and they're going to have to start thinking about sources of revenue. Some of those sources of revenue will basically be lined up and ready to go. So if the CPA committee wants to appropriate money into it, they're good to go. But in terms of identifying other revenue streams, that might take a special act. So even though I don't know that I think that something can necessarily be done, or it's likely to be done with respect to changing the way that we calculate building permits, I think could be wrong, but I think that that's how we do it. This idea that we could take a percentage of building fees or building fees in certain scenarios and have some of that go over the Affordable Housing Trust is certainly something that could and should be explored.
Thank you.
Okay, so we just have a few minutes left. Last calls for any quick questions. And seeing none, so I think that this is a good stopping point. So yeah, I just wanted to thank especially Doug and Mike for being generous with their time and explaining so much and fielding all the questions. And also thank everyone for participating in this. This is just, like, we're very early on, like, in our civic engagement efforts. I'd love for us to have more events like this and kind of like broaden kind of the landscape of access to resources like this. And so, Doug, thank you so much for being a really helpful resource tonight. We're going to try to post this online for folks who weren't able to join tonight, and put content out there like this as a resource for folks to figure out their way through kind of this complicated civic landscape. So thanks everyone for participating in this, and have a good night.
Thank you, guys.
Bye-bye, everybody. Thanks, Mike and Doug.
Thanks.
Everybody else.
Take care, folks.